And his client is not available. He is not willing to. Not willing to. No. Make a matter then. I don't know. It's already been heard, my lord. It's okay. For clarificatory hearing, we'll fix it in the next week and then we'll deliver it. Okay. Thank you, Pastor. I have empty documents. It's fine. Name? No, your name? Mr. Interest. The customer and research is yes, my lord. Yes, my lord. Mr. Concluded. Yes, you will take next week for clarification. Yeah. Thursday one. May I please, your lordship? Lord, I am praying for one IA. Please give it to the co-constable. All listing, give it to the co-constable. They will have to make some adjustments.
May I please, your lordship? Lordship, I beg to mention item 31 of today's list if it's going to be taken up at 2 today, lordship. Item 31, a very short order needs to be passed. It's a transfer application. I am for the respondent and we are giving a no objection to the transfer, lordship.
Inform the other side.
The other side is already present, lordship.
Take it up.
F2, lordship. Deeply observed. 31.
I beg to mention item number 5. Here the petitioner is died, lordship. I want petitioner is expired, so I want to file implement petition. So the Bhutan Bank Council for the petitioner submits that the petitioner has expired and therefore we wait for some time to take instructions and to do it. That's the job today. List after 1 week. After a week. Okay.
Lordship, I need to mention item number 44. In one I is there where we have not mentioned about the date certificate that at given point of time. I may be allowed to file annexer of that date certificate for implement of the petition. Yes?
44. What document is left out?
The date certificate.
What is this application for?
Implement of the
For implement.
Yes, Lord.
Let us follow it, then we'll see.
Lord. Deep
Let us follow it.
Lord, please, Lordship. With the consent of the respondent, I beg to mention item number 20, Lordship. Admission method. If I kindly adjourn for 1 week, Lordship. Conducting round to Lordship is out of station.
20.
Yes, sir.
Okay, with consent of the consent of the respondents. Mr. Sharma and cost for the additional place for adjournment. There is a vote. Next week, based on transfer. Yes.
May I please, your lordship? I beg to mention item number 6 with the consent of the other side.
Item number?
6, your lordship.
Yes.
I have circulated the adjournment slip, your lordship.
You are for the petitioner.
Yes, your lordship.
So that's presented. Circulating an advance adjournment memo from the land cost for the petitioner place for adjournment. Period is allowed. List after. How much time?
Yes, your lordship, please.
Ideal lordship. Subject to lordship. You did next week. Yes.
Lordship, item number 20, interim is there, Lordship.
20 interim is there. Okay. 20 interim.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 22, my lord.
22.
22, my lord.
Okay. You are taking consent?
Yes, yes.
Okay, both sides are represented on the prayer made by land council for the petitioner. List after.
Subject to your lordship convenience, can it be on 8th, my lord, 8th of June?
8th of June. 8th of June. Okay, 8th, 6, 2028.
My lord, can it be changed to 10th? My lord, if it is not an inconvenience, can it be on 10th of June?
10.
Okay. My lord, there is an interim order operator.
Okay. Interim order passed. The list has extended till the exit of the state.
Yeah, please, your lordship, I beg to mention item number 10. Lordship, in this matter, we have to file an IL. Actually, there was some omission in the pleadings. So, kindly adjourn the matter for the day.
Okay. The land council for the petitioner submits that there is a inadvertent error in the petition and therefore he intends to file an interrogatory application for amendment, whose prayer is allowed. Attestants adjourned to the list.
Maybe on first week of June.
The list as and when the interrogatory application is filed. Okay.
Address. May I please, your lordship? Lordship, we have filed one arbitration appeal, which is defective because we could not submit the certified copy of interim order passed by the sole arbitrator from Chennai. Lordship, like, there are some direction in the order where coercive action may be taken immediately, Lordship. Lordship, we had already approached the registry. They told us to mention it before civil bench 1, Lordship.
You approach the registry for what?
Registry for, sir, for filing. Sir, for filing. Okay. Sir, did mention it before civil bench 1.
I think you do not need our authorization.
Sir, it is defective. So because of the certified copy, I could not provide.
No, if you rectify, it will come. If it is defective, what can we do?
Sir, my prayer is that sir, kindly allow us to file the arbitration appeal, sir. Otherwise, coercive action will.
But it can't be given. You'll have to file something. If there's a delay, there'll be a confirmation application. If there's a defect, we'll have to cure the defect. The registry never prohibits you from filing an arbitration appeal.
Lordship, this is an ex parte order and we even do not.
Whatever it is, the registry will never stop you from filing. The first time I'm hearing in this court that the registry is not taking your filing. Can't be acceptable. If it is defect, it will never be listed. We don't want defective applications to come before the board. It will never come. We have been misinformed. We have not seen. I've never heard the registry not accepting a filing. Yes, item number 1.
May please, Your Lordship. In this case, we have filed an IA under order 6, rule 17, Your Lordship. There is some typographical and canonical mistake has been committed in the petition, Your Lordship. So, may I plead with you, Sir, to come up the this petition and text along with the IA, Your Lordship. We have because of the clerical mistakes, Your Lordship, we could not take the steps upon the defendants, respondent, Your Lordship.
I'm sorry, I'm not getting you.
Lordship,
You say
an IA has been filed under order 6 rule 17 for amendment or correction of some of the typographical error made out in the petition. For which while order passing in the order, the title execution number has been written as 24/22.
Okay.
Lordship. So
22 file it?
yesterday we filed, Your Lordship.
Right, forward and for the petitioner. Which that an interlocutory application has been filed for amendment of the application. On 21/5/2026, they said application is not on record. You have for the comment?
Lordship. Paper number 1, Lordship. Copy to person. Extra copy also not been served to us, Lordship.
Steps also is not taken.
Step also not taken to restaurant number 2 entry. Because of some that mistake, Your Lordship, the registry has told us to rectify the entire defect, Your Lordship.
the government is good for respondent one is present and submits that extra copies have not been furnished. Full stop. We also note that despite order dated 31/10/2025, the petitioner has not taken any steps for service of notice on the respondents. So therefore, the interim order passed on 31/10/2025 stands vacated. So you file an application, you can't have a default. 6 months you have met its state.
No, because
The registry shall transmit downloaded copy of this order to the learned civil judge, junior division, bracket close number 1, Dhubri. Make it a part of record of T execution case number 24 of 2002.
but it is 2026.
We don't know, you have not taken steps. For more than 6 months, the execution is stayed.
Because of the mistakes here, the registry has asked me to rectify it.
That you think, they have asked you to correct it in 6 months, you are sleeping after getting an interim order.
The petitioners have.
File an application, we are not restoring it. Once you don't take steps and keep it pending for 6 months, you don't get that leave to continue the interim order. You have stayed in execution. After that, you will come with the excuse that only the A is missing, B is missing. You have to correct this, you have to correct that.
That will execution number.
You do whatever you want.
Lots.
We are not extending the interim order.
Lots.
Once you don't take steps.
Well, since then,
Okay.
may I pay for it another?
This as and when the list along with the interim interlocutory application
Lots.
on when
After the after a week.
this transfers.
Lots.
Item 2. Which page is that petition? 26. Where is that petition dated 26?
Dated 260 certified copy of the 75,
75.
page number 75.
You are the judgment debtor.
Yes, where is husband?
Where is the report of satisfaction by the Nazir?
It is at page.
Hmm.
59. Page 59.
And where is the execution petition and the decree?
Page 41.
we are asking about about this for a reason. You see at page 39 is the decree. This decree is land measuring 1 bigha, 1 katha, 11 lacha. Then in the execution petition, the decretal land is page 44, 1 bigha, 1 katha, 11 lacha. Now, in your petition, you say that decree in respect of Schedule A and Schedule B land. Where does Schedule A and Schedule B come from?
Bharat, the whole thing is this. They have, in their plain, they have stated that we are in unlawful possession of Schedule A land. And
Yes.
they paid for degree of Schedule A land
Yes,
and confirmation of possession so for Schedule B land.
yes.
So Lordship kindly turn to page 22. Here it is stated. A few 10 lines from the top. Describing in Schedule B of the plain one, surreptitiously and illegally.
You are reading where, page 22?
22.
Which page? Acha. In Schedule B land. And 4, 5, 6, 7, 8, and 9 from Schedule A land.
A land. A land is different and B land is different. And they are prior for eviction from Schedule A land. And you will also kindly see it is very interesting. In this schedule, there is no Schedule A.
No, there is no Schedule A. That's why we are asking you.
That is the plaintiff played a fraud upon the court. Without mentioning the Schedule A in the plaint, they got the decree
Where
executed.
is the Nazir report saying that the execution is complete? Where is that? Nazir report that the execution is complete?
Execution is not complete.
No, they have made a statement somewhere.
Yes.
There is a specific statement that the execution is over and therefore re-execution.
Well, thereafter they filed a petition that execution is incomplete.
But where is that report of the Nazir that this execution was completed?
It is 59 or 60,
59.
59. Decree has been executed.
Yes, that's.
As the rate returned back, that execution.
Remember what happened after this 22/5/2025? This objection at page 60, who had filed this?
We filed a petition on 2/6. That is the petition.
No, this page 60 is what? Who has filed this?
Which one?
Page 60.
Yes, page
Who has
60
filed
we
this?
have filed.
Who has filed it?
We filed.
You have filed.
Yes. And we, in this petition, we paid for some
But
time.
why have you filed this after satisfaction?
No, the decree holder also filed a petition. The decree is not fully executed. We also say that the decree is not executed, but we are in possession of some part of the land. Their petition your lordship will get.
So because there's no clarity. In this page 60 application, you, in the body of in the cost title, you say objection. But in your prayer, you say you give me some more time for objection. There's no clarity on what you are praying. See the prayer at page 60 petition, see the prayer.
Thereafter we'll find it, thereafter we'll find it this petition. By page 75 annexure 30.
Mr. Ahmed,
Well,
you see, you say that the defendants, the decree, the judgment debtors are still in possession. After execution, satisfaction of execution. Against the report of the Nazir,
my lord,
there is no protest.
my lord, in that case, the Nazir was appeared before the executing court.
Yes.
And after hearing, Nazir himself stated that we, the team of the Nazir, evicted and demolished the wall, boundary wall. And the tin shed is also over that house. That part admitted, and that is why,
Tin shed.
yes, my lord, it is wall of the house is demolished, but the tin is over the house. That is the, my lord, in the order, that is after filing the petition under section 47, the honorable trial court called the Nazir before the court, and on hearing, on asking that, the Nazir stated that upon heard, my lord, execute that order at page 72, my lord. It is 26/5/2025. Nazir submitted in court verbally.
Where you are reading?
My lord, page 72, my lord.
70.
Annexure 12. 72. Middle portion, my lord. It is to be noted that the Nazir submitted in court verbally that the said house standing on the shoot land was demolished to the extent of removing the belongings of the defendants and the walls, but the roof was left standing.
So how does it matter? How does it matter?
And may I read, my lord, subsequent part, my lord? Had the decree holder who appeared in the court as per the decree holder, he had put his thumb impression on the execution report that he was satisfied with the execution upon being convinced by the Gauhati that the remaining structure of the house of judgment debtor standing on the shoot land shall be removed in time period of 2 days.
If the house is broken and tin shed remains, how can you say that the execution is not complete? You are the decree holder.
Yes, my lord.
How can you say that it is not complete? Please tell us.
My lord, it is from the hearing of the Nazir and on convincing by the Gambura, the decree holder puts,
Once you have recorded satisfaction, then this Nazir report has to go first. Decree once satisfied, and there is no decree for permanent injunction. You have to file a second suit for eviction.
my lord, as it is the court, the executing court.
So what can only be done is to remove that roof, nothing more.
Yes, my lord, that roof should be removed from there, my lord.
You have difficulty in taking that roof.
Yes, my lord,
Position.
they
You took possession of the land or you did not take possession of the land?
We took possession, but part of removing the roof, the judgment debtor again raised objection. And they filed that petition after objecting that we are in possession. On their presence, the
That's what you are saying. If after eviction,
My
somebody is in possession,
my lord,
you'll have to file the second suit. There is no permanent injunction granted, which makes the decree executable under section 36.
my lord. But my lord, section 47, sorry, my lord.
47 will not exist. The execution petition is closed. Once an satisfaction of the execution is recorded, it can't proceed.
But after that petition filed by the JD,
It can't be entertained. You file the
that
second-
petition is not entertained, my lord. The present
Your
petition,
petition is not be entertained.
present petition is not entertained, my lord. As because Honorable Supreme Court also said that decree must satisfy
Hmm?
in
It is
some,
satisfied. The satisfaction is recorded. The charges
and
given.
after satisfying that, the petition under section 47 is not maintainable. One judgment, my lord, in 2019, cited in SCC. And the learned executing court rightly rejected the petition of under section 47, my lord. And after rejecting that 47, again,
See, this story is just not acceptable. You come to court, the Nazir says that the roof is standing. Then you come and say that the judgment debtors are still residing there. How can they reside only on a shed with no walls, no house? Either of you have to be false. Please tell me, how can a person live? How can a family live on a premises which has no walls, but only roof?
my lord, defendants, judgment debtor not living there, my lord.
Your then petition at page 67 is false. In page 67, you say the judgment debtors are still residing and standing on the suit land. So they are residing by standing on the suit land. They are not cattle or horse to reside in a standing on a suit land. Cattle I can understand, horse I can understand. They can sleep while standing.
In that petition, my lord,
Page
The-
67, you gave me this petition, I am ready to answer it.
my lord, 67, my lord. It is executed. They could not completed the execution and the judgment debtors are still standing. Judgment debtors are still residing on their residence, standing on the said land, and they are not interested to leave the Sudan. It is,
Residence is broken. You, first the Nazir, if you believe on Nazir, then the Nazir says only roof is there.
my lord,
Now you come and say the residence is there. You don't give photographs, you don't show us anything.
Right.
And you say that please carry on execution. There's no two schedule land. In your plaint, you say schedule A, schedule B.
Yes.
But decree becomes inexecutable.
and in decree, my lord, it is stated schedule B, my lord.
There's nothing. There's nothing in that decree showing A and B. We showed you that page. Every time I don't have to open and tell you which page is that. Look at the decree. What's your plaint? In the plaint, there is only one schedule. Then you come to the decree, only one schedule. In your executed petition is one schedule.
Not identified either A or either B.
Then how can how can the execution proceed?
It is only written the tag number and the area of the land.
I know that, please don't repeat that. Give me an answer.
But it is true, my lord, in the schedule of the decree is not identified, my lord.
Then how could the decree be, you see, the decree satisfaction is recorded. Then both of you come and say that it has not been executed. Nazir comes and gives a statement. We will direct the Nazir to be disciplinary proceeding to be drawn up. If this is being done in the execution proceeding, we'll ask them to examine if the Nazir, there should be a disciplinary proceeding. The administrative side will make a request. Nazirs are bringing bad name for the court while executing decrees. They have opened up a kingdom. They'll do whatever they want. There's no material before us that the execution was not satisfied. And while we are dealing with article power under Article 227, we are not bound only by the prayers. We are exercising superintending jurisdiction. It will not prevent us from examining the nature of execution. So this is first time that I am hearing that somebody is asking for re-execution only because there is a clean sheet proof on the wall. Tomorrow, if for some reason advocate's house is what you call the tenant, advocate is a tenant, his house is evicted, will he come back and say that no, my Constitution of India was left there and therefore please start the re-execution? This book is not there, I could not take it. It was left behind and they are not releasing the book and I want this book to be released, so please re-execution. Can that happen? Your ground is frivolous, you will seek an execution only because there is a team group. And then you expand your petition when it comes to this petition. Now you say that they are living at that house. Where is the existence of the house? There is no Schedule B land, there is no Schedule A land, and you want an execution, and the court is ready to give you an execution. So we'll send it back.
Better to
The court will give directions that the court will not proceed with the execution unless the satisfaction is recorded as to what remains from execution. And the Nazir who is involved will not be engaged in this matter. For execution, he will not touch this record. This can't cannot be allowed to happen. Something horribly wrong.
And whether they are also playing for the 24 because there is no Schedule A in the plaint. There is no Schedule A in the plaint.
Not there, but there are pleadings of Schedule A. There are pleadings of Schedule B. That's why the confusion. That's why I started asking you of that petition. So while reading, I was very confused as to what is happening. I could not understand. Therefore, I had to get the matter to understand what is going on. No. Where is the order included, Mr. Sharma?
At page 72.
72. And what has happened from 26/5/2025 till today? The operating
We filed a petition that is
state.
thereafter the case is 8.
Mr. A.C. Sharma, then senior counsel, assisted by Mr. G. Bhardwaj, then counsel for the petitioners. Also heard Mr. K. U. Ahmed, then counsel referring for respondent numbers 1 and 2. K. U. Ahmed, respondent. Next one. This application brings this application exposes the difficulties which are created by the civil nazir while executing the decree, which has led to a very anomalous situation. Next one. The plaint annexed to this application as Annexure 1 contains pleadings of two distinct scheduled land. As per the statement made in the plaint, the respondents, plaintiffs, are seeking ejectment of defendant numbers 1, 2, and 3 from Schedule B land and eviction of defendant numbers 4, 5, 6, 7, 8, and 9 from Schedule A land, which is more fully referred to in paragraph 2 of the plaint. To stop. However, moreover, in the prayer made in the plaint, the respondents as plaintiff have prayed for a decree for declaring right, title, and interest of the plaintiff over the suit land, Schedule A and Schedule B land. That is A. Huh? Then semicolon B, decree for declaration that the plaintiffs and defendant numbers 1, 2, and 3 have undivided right, title, and interest and possession over Schedule B land, and the defendant numbers 4 to 9 are mere trespassers to Schedule A land and are liable to be evicted from Schedule A land, semicolon. And there is a page 26, huh? A, B, C, D, E. Full stop. In contrast, in the schedule of the plaint, you please, the schedule of the plaint, which is at internal page 9 of the plaint, the land shown in Schedule B is 1 biga 1 katha 11 lechas. Full stop. There is no reference to Schedule A land. Full stop. Therefore, from the statement made in paragraph 2 of the plaint, the petitioners, the respondents are seeking ejectment of defendant numbers 1, 2, and 3 from the Schedule B land. Full stop. The suit was decreed ex parte decreeing that decreeing eviction of the defendant numbers 4 to 9 from the suit premises and restore their possession over the suit premises. Stop. Thus, comma, the decree is ex specie in departure of the statement made in paragraph 2 of the plaint. Stop. And the prayer made in paragraph prayer B made in the B and C made in the plaint also appears to be contradictory to statement made in paragraph 2 of the plaint. Sorry. It appears the appears to the plaint as in paragraph 2 of the plaint, sorry, it is reiterated that in paragraph 2 of the plaint, the relief shortfall was for ejectment of defendant numbers 1, 2, and 3 from the Schedule B land. Full stop. Be that as it may, the decree drawn up is for eviction of the defendant numbers 4 to 9 from the Schedule A land. And the schedule of land is 1 biga, 1 kata, 11 lecha, without any bifurcation of land in terms of Schedule A and Schedule B as referred to in the plaint. Let's start. The said decree was put to execution by filing an execution petition which was on 29/4/2023, which was registered as title execution case number 7 of 2023. Stop. The nature of assistance required under paragraph 11 of the execution petition is extracted below. 43. Page 43. Your execution of decree would be fraudulent, Mr. Ahmed.
Well,
Your execution of the decree, nature of decree sought to be executed would be fraudulent. It's a fraud on the court. Page 43 makes it a fraud on the court. Once it is fraud, consequential orders will also be passed, restoring possession to the judgment debtors. Stop. Next, where it appears which page was that Nazir report? 59. The civil Nazir, Kamrup Amin Gaon, is reported to have filed a report regarding satisfactory execution of the decree sought to be executed by title execution case number 7 of 2023 before the learned civil judge within bracket junior division bracket close Kamrup Amin Gaon on 22/5/2025. Full stop. Next para. On 23/5/2025, one of the petitioners this is filed by defendant numbers 1 to 7. Mr. Sharma, case 60 petition is filed by whom?
1 to 7.
Defendant numbers 4 to 9 or
1 to 7.
huh? No, there's something wrong. You see, in page 60, that's why I said your petition is more confusing. Page 60 petition says against eviction of 4 to 9. If it is 4 to 9, then there are 6 people. 7 people can't pay. Page 61, page 60 and 61 is 7 people. 4, 5, 6, 7, 8, 9. So one more has come in, and we are not sure who are these people. Moinul Haq.
Moinul Haq, dependent number 1.
So person against whom the decree is not executed, he is before us. The respondent numbers 1 to 7, who are defendant numbers, the defendant judgment debtor numbers 1 to 7, have filed petition number 1254 under dated 23/5/2025 under section 47 of the CPC for stay of the proposed eviction of the defendant numbers 4 to 9, the defendant judgment debtor number 4 to 9. Therefore, it appears that the present petitioners are not the persons aggrieved by the eviction proposed against only the injury of the cost title, where the objection is against eviction of defendant numbers 4 to 9. Next one, be that as it may, on same day, The respondents decree holders have also filed petition number 1249 dated 23/5/2025 before the learned executing court, stating that that on 21/5/2025, the the persons engaged in the execution went to the suit land but did not complete the execution, and the judgment debtors are still residing on their residence standing on the suit land. Full stop. Therefore, comma, both sides appear to be aggrieved by the nature of execution ordered. Next paragraph. Next paragraph. Surprisingly, the Nazir was in charge of the execution, made a volte-face statement in which appears from the order dated 23/5/2025, passed by the learned civil judge within bracket junior division, Kamrup Amingaon. So by the said order, the learned executing court has recorded sorry, 26/5/2025. The learned court has recorded that upon perusal of the report of the which is quoted below, page 72. Relevant part is quoted below. Thus, comma, it appears from the said order dated 26/5/2025, comma, that the Nazir did not support his own decree satisfaction report and made a contradictory stand to the effect that the verbal stand before the learned court that the house in the suit land was demolished to the extent of removing the belongings of the defendants and the walls, but the roof was left standing. It is surprising to note that the ex parte decree dated 20/10/2022 does not permit demolition of the suit premises, suit houses, the houses standing on the suit land. So therefore, the decree that was ordered on 20/10/2022 is extracted below, page 38. So the decree merely, from the above, it appears that the decree merely states that the defendant numbers 4 to 9 are directed to vacate the suit premises within 30 days and hand over vacant position of the to the plaintiffs and defendant numbers 1, 2, and 3. And they were permanently restrained from interfering with the peaceful position of the plaintiffs. As stated earlier, out there. Therefore, comma. Also appears that the execution exceeded the mandate of the learned trial court and the learned executing court. Next para is the factual aspects which has emerged out of this this application, comma. There are disputed questions as the plaint because of the nature of prayer made in the plaint, comma, the nature of schedule given in the plaint, comma, the nature of decree passed, and the nature of execution carried out, which requires the executing court to cause a survey of the to do the needful to ascertain the correct position of the nature of execution that has been carried out. Next part. Therefore, comma. The court is inclined to set aside the order dated 26/5/2025 and the execution petition and the execution proceedings, comma, the learned civil judge in the Kitchener Division from the Birmingham is requested to examine the statement made in paragraph 2 of the plaint, comma, the nature of prayer made in the plaint, or the nature of decree that was passed, comma, the report of the Nazir, and they've also determined and shall also ascertain as to the current position of the soup land. In the considering the opinion of the court, examination of these would not amount to go behind the decree, but the exercise would be to see the executability of the decree also, and to find out if that actually which of the defendant is sought to be evicted, because the plaintiffs are found to have made a prayer for prayer B for declaration that the plaintiffs and defendant numbers 1, 2, and 3 have undivided right title interest over the and possession over the Schedule B land. And therefore, it has to be ascertained that it is for that said reason, the court finds difficult to adjudicate the matter because in the plain there's the schedule B land. Is available and the schedule A land from which defendant for which player in paragraph B is where B is made is for declaration that the plaintiffs and the defendant numbers 1, 2, and 3 have undivided right, title, and interest and possession over Schedule B land, and the defendant numbers 4 to 9 are mere trespassers to Schedule A land, and they are liable to be evicted from Schedule A land. Thus, comma, when the plaint contains plaint as the copy of which is produced in this is annexed to this revision only contains Schedule B, comma, the said factual aspects has to be examined by the learned executing court. Next paragraph. In view of the nature of acts that are done by the civil nazir of the court of civil judge within bracket the court of civil council at the establishment of the district judge, learned district judge, Kamrup Amingaon, comma, this is required to be dealt in an administrative manner. A civil nazir giving a report of satisfaction of execution of decree, if turns, it makes a U-turn and then says that the execution was not complete. Parenthesis shows that the action of the civil nazir is not liable and is not conducive for effective dispensation of justice by the civil courts while executing a decree. Therefore, comma, the registry shall put up the matter before the fully judge on administrative side with intimation to the next paragraph. As both sides are represented, comma, both sides are directed to appear before the learned civil judge in bracket junior division Kamrup Amingaon on 5/6/2026 and by producing a certified copy of the order with further orders to be passed by the said level. Next one. Till the date of appearance of the parties before the said learned court, which is fixed on 5/6/2026, the interim order staying the operation of order dated 26/5/2025 by the learned executing court shall continue, and the said order shall lapse on 5/6/2026, on which date it will be open for the learned executing court to pass appropriate orders. There's one statement I've got. So the learned I've said that it will not amount to going behind the decree. In that language, you adjust these words. You also say that this is also the purpose of this direction is that the learned executing court must have a clarity on the nature of execution that is sought to be executed. It is also the duty of the learned executing court to find out whether the decree passed is in accordance with the prayer made in the plaint. Moreover, as the nature of assistance sought for execution appears to be in departure to the decree drawn up, or this examination is required to be made. Last, the learned executive court is requested to take up the proceedings. In an expeditious manner, without granting any unnecessary adjournments to any sites during the or on the dates fixed, except, save and except if the adjournment is occasioned by death of any party. Only on death adjournment, no adjournment otherwise.
Right.
In this case, I have to take fresh steps because notice has been returned unserved, my lord.
Address cannot be located.
And the address I have given from the execution petition itself says 18, my lord.
Page 18.
18.
Page is the execution petition.
Petition is at page 14. And address also mentioned in the basic order, page 18 also. Decree holder.
All of nursing food part 6.
All part 6.
Known as Tata Khal.
No, it is with respect to the petitioner, no? Respondent's address is the decree holder.
Respondents are the degree holder.
Yeah.
Part Jamila, part 6.
Bordalanga. Yes.
You are not given part 6 in your address. And you've given this PS is Bholai, you have given Silchar.
No, it is from page 18 can be seen. Exact address.
Page 18.
18. And PIN number also I have given.
So that is okay, but you now got the execution petition. Here the address is different. Part Jamila, part 6.
May I take this steps, Manoj?
So you have to bring it on record,
Yes.
the correct address.
Yes, please.
Okay. Mr. S.T. Ghosh, counsel for the petitioners has submitted that as per the office note dated 4/5/2026, but the notice is reserved, returned unserved, as the addresses could not be located. So he has referred to the notice of execution, which is annexed as annexure P to his application. And it is submitted that the address of the respondent is exactly the same as given in the notice of execution in TX case number 13 of 2015. Is submitted that the address given in the notice did not contain pin code in the cost title of this application. Petitioner has only inserted the pin code for effective service of summons. Service of next one. The perusal of the materials on the whatever on the report, seen that in the execution petition annexure as annexure 2, the address of the respondents is stated as Parjalanga, ParjalengA, Part 6 of PS Blind, District Kachar, and phone number is also given. You have to come on. Having noted that the from the address from P, it would be a quick case to permit the learning transfer for the petitioner to make necessary correction of the cross statement in respect of the address of the respondents by hand in the presence of POK, Civil Division Section of on corrections being made with update the parents data. Next. Possible. The petitioner shall take fresh steps after correction of the concept. The 4 days from the date of the order for service of notice on the respondents by speed post PD. The addition from the correctly the learning council for the petition that is number that was reached the thing. Next, addition to usual step as the phone number of the judgment decree holders in capital execution number 13 of 2015 is provided. The notice processed by the registry shall sent by any messaging platform available in the mobile and for service from affidavit of solution is fine. In addition, the court is inclined to direct that the petitioner shall lose a certified copy of the order before the next civil judge in Junior Division number 2 approximately along with a copy. Bring the order, this order to the notice of said knowledge. As such, number 4. Easy order pass is time constantly. Then certificate copy. Next, this term, your data for police. My lord, may I indicate in addition by way of usual process? Usual process. Registered as well as by you also serve through that mobile number. mobile. You have given. But who is time to take steps and to put in it correction?
No, please, okay. There was on the last occasion.
Will allow this application,
Lordship,
but his speech of it and answer for the applicant. Also heard Mr. E.R. Shalom, the council appearing for on numbers 1, 2, and 3.
Lordship.
And you are appearing for 3 and 4. And
1, 2A, 2B, and 2C.
2A, 2B, and 2C. And Ms. A. Barwar and council appearing for respondent numbers 3 and 4. Next. By filing this application under section 146 of the CPC, the applicant, the applicant has stated that the respondent number 2 will be Prakash Sekia had expired on 11/5/2019. During the Prakash Sekia is respondent number 2. He respondent he died on 11/5/2019, leaving behind 3 legal representatives whose names are mentioned at paragraph 3. Filed on 27/2025. No, filed on 9/2/2023. Going to the substitution of the respondent number 1. That was great. That was great. So the current function for the respondents are going to fail, considering the reasons assigned and taking into consideration that the applicants projected the cause of action to survive. So right to sue survey from a here is allowed, and the respondent number 2 is permitted to be substituted by the legal representative since other particulars are disclosed at paragraph 3 of the next one. The application stands allowed, including the application stands allowed with the full board. CRP third also. In view of the order passed today, I guess 862 of it. Substitution of the one of two, the petitioner. Shall file an amended offset of this revision application 3 working days. The AOJ civil division section and the according incorporated in this revision petition. And for updating the CIS data. Thereafter, the matter to display again. At the end of it. Just give a date, will be. Give a date. Case of 2006. So I was just considering looking at your application. In the CRP, please come to page 24. In your CRP, please come to page 24.
24. Yes, my lord. Judgment, judgment, my
There are
lord.
5 people here. Saru Gosho, Prakash Soikia, Atul Soikia, Bhupati Soikia, and Makhan Soikia. 5 people. And the shares are determined at 1/5.
Yes,
Correct. And then you file an objection saying that your right is not determined.
there are 2 schedules, my lord.
Hmm?
2 schedules. 3 schedules, in fact, are there in the plane. So far as schedule B is concerned, I am not agreed, my lord. But so far schedule A is concerned, that was the land which devolved upon me from my late father, my lord. And that got devolved from
our mother. So from that piece of land, I am totally excluded because the judgment was passed in abrogation of the Hindu Succession Act. I am the class one error, my lord.
But then you can't object to it. You'll have to file an appeal.
My lord,
You're,
no, court has
once there's a
completely
decree.
finding that I had no objection. I never relinquished my right, and the WS which was filed, that was not properly executed. Order
But
6.
then it's a case of appeal. How will this revision be maintainable? You filed an objection to execution.
You know, renew, my lord, my humble prayer before lordship. The matter may be heard on merit at a fixed date, my lord, because today I'm not prepared also. So let a date be fixed, my lord, except 2nd June and 5th June. I have personal difficulty.
The matter is being fixed on 3rd of June.
For June, in June. Obviously.
Yes, item 4.
Please, your lordship. Previous learned counsel had withdrawn the wakalatnama. Thereafter, the petitioner engaged the present counsel and a fresh wakalatnama has already been filed. The observation recorded by the learned court below the petitioner remain unpresent before the honorable court appears to have been made without proper verification. So during the pendency of this suit and despite subsisting status quo order, permanent construction have been raised over the suit plan. Instead of deciding injunction violation, application expeditiously, the matter has been unnecessarily being prolonged to evidence state, thereby frustrating the very purpose of the interim protection.
You're aggrieved by which order?
Order, order number order dated on 26/2/24 is in Annexure 6, order number, case number, Ms. J, case number 49, page number 52, Annexure 6.
This injunction application, the injunction order you are challenging here under 227,
Yes.
is it permissible?
Two 227.
Is it permissible? Injunction order being challenged in 227, is it permissible? You are the plaintiff or the defendant?
Plaintiff.
You are the plaintiff.
Yes.
Both sides were directed to maintain status quo and you are challenging the order.
No, there has been some erection of permanent construction was done. And
For that, you challenge the injunction order.
we just want protection of the suit property, restrain from further construction, and maintain of status quo. If needed, LCR can be called.
Your name?
M. Islam. M. Islam.
M. Islam. Heard Mr. M. Islam, the counsel for the petitioner.
Yeah.
The petitioner is the plaintiff in title suit 10 of 2023. Stop. The petitioner had filed an injunction application under Order 39 Rules 1 and 2, read with Section 151 CPC before the Court of Learned Munsif number 1 at Sivsagar, which was registered as NISJ case number 49 of 2023. The said learned, the learned Munsif number 1, sorry, civil judge within bracket junior division bracket because number 1 Sivsagar, by an order dated 26/2/2024, considering the materials before it, was of the opinion that the preservation of the suit, the subject matter of the suit was required till the court adjudicates the disputes, and accordingly directed both sides, both parties to maintain status quo over the line. And accordingly, NISJ case number 49 of 2023 was disposed of on contest by the said order dated 26/2/2024. Full stop. It appears that by alleging violation of the order of injunction, application has been filed by the petitioner under Order 39 Rule 2A of the CPC, which was registered as NISJ case number 55 of 2024, arising in PS 10 of 2023. Full stop. In the set proceedings of major case number 55 of 2024, as per order dated, as per the last order sheet annex dated 1/4/2025, the case was switched on 5/2025 for further evidence of the petitioner's side. Full stop. With the said background, comma, next paragraph, with the said background, comma, the petitioner has filed this application under Article 115 of the Constitution of India, read with Section 115 of the CPC. To stop the prayer contained in this application is extracted below, page 16. Next paragraph. This application is nothing but an abuse of the process of court. Full stop. While the petitioner has already approached the learned trial court for by filing an application under Order 39 Rule 2A alleging violation, comma, it is out of it is comma, the clear made for directing the respondents to show cause as to why appropriate orders should not be passed for violating status order is totally that too under Article 227 read with Section 115 of the CPC is not tenable. Under Article 227 of the Constitution of India, the court exercises superintending jurisdiction, and under Section 115 of the CPC, the court is exercising revisional jurisdiction, and the prayer made in this application would amount to an original adjudication, which is impermissible under both the provisions of law. Next, according to this revision, and this application stands dismissed. Next, the registry shall send a copy of this order to the learned civil judge, like a junior division number 1, Sivsagar, for record.
Lordship, in item 7, we file an IA today. It is not been tagged with the matter. We have filed an IA for correction of amendment of title. Not on the record. May it be listed with the IA?
When did you file it?
Today.
Today. For amendment of cost title.
Cost title.
The John the matter was not here. Sir, Singhal and Pastor, for the petitioner submits that an interlocutory application has been filed today for amendment of the cost title. Mr. Dissent. The registry shall place and tag this application on, on record. Yes,
As per
as per the council,
appearing
for-
on behalf of Mr. B.K. Mukherjee.
okay, for the, all the respondents. Okay, so all the respondents. There's only one respondent. The applicants are several, applicants and respondents. List list along with this interlocutory application.
This also tagged with this matter only, 7 and 8.
It passes a problem. In view of other past in CRP 35 of 2026, or list as and when the CRP 35 of 2026 is discussed.
Obliged lordship.
Find out whether there is any defect or not in that application.
May please your lordship.
Yes.
And also we have filed this petition, CRP, against us, against an order by which our petition under section 47 was rejected.
Section 47.
Yes,
Where is the copy of plane?
Your lordship.
Where is the copy of the plane?
Copy of the plain, your lordship will find that page number 28, your lordship.
28. And who are you?
My lord, I'm sorry, I was added as the pro forma defendant in the main suit, 1 to 7. The suit was basically filed by the plaintiff seeking declaration of right to interest and partition, as well as recovery of possession.
You are pro forma defendant.
Yes, my lord. And this suit was decreed in favor of the plaintiff ex parte. My status is that I purchased some part of the suit land from the co-sharer much prior in point of time the filing of the suit.
You said that you are pro forma respondent. Where are you in this plane? Page 16, where are you?
Yes, let to go. Page 28, my lord.
Where are you?
7 to 11.
7 to 11. Mujibur Rahman,
7 to 11.
yes, relevant 29 page.
Yes.
So what the suit was proceeded ex parte against us, though the record shows that the Laurel court also came to a conclusion that the summons were received by the pro forma defendants. In fact, no summons were received by the pro forma defendants. While going through the record in the court, we came to learn that one person has received the notice. One of the pro forma defendants, Dilwar Hussain, pro forma defendant 9, on behalf of others, putting his thumb impression, whereas he is the literate person, he doesn't put thumb impression on any paper. So this was the discrepancy we discovered from the record. Anyway, we filed a 47 petition before the learned court, though the learned court has issued a precept directing the collector to do the partition under section 54 of the CPC. So in the meantime, when a circle officer arrived and visited the place in the suit land, we came to know about the decree passed by the learned court. We filed our objection before the circle officer without any, but it was not, no order was passed. Then subsequently we filed, though we were late in filing the 47 petition, we have filed the 47 petition, which your lordship will find at page 110.
Yes.
But here our basic contention before the learned court was that no, the paragraph two, that no summons upon the petitioner has been served, and as such the petitioner have no knowledge about the case earlier. The petitioner have come to know about the case only when the circle officer, Dolgaon Revenue Circle, has visited the suit land for partition of the suit land, and thereafter the petitioners applied for certified copy of the plain judgment and decree, and after obtaining the same, the petitioner could come to know about the fact of the case. In the, as per the decree passed by the learned
Here,
court,
this section 47 application would not be maintainable. You did not file an appeal, you did not get the decree set aside.
yes, that is
Now
true.
you file an application which amounts to the court going behind the decree. You are laying claim to as the title. It can't be gone into.
That is true, madam.
Then
But, with the help of the decree, my portion of the land which I purchased from the co-sharer, 3 bighas of land, I have been, dispossessed, part of the land, because she has obtained a decree for a particular portion of the land, 12 bighas, which includes my land.
this is, you see, it's a partition decree.
Yes,
In a partition decree, the shares would be determined, whether you have a share or your vendor had a share, will be determined while the preliminary decree is settled and the final decree is drawn up.
But even-
You say that you have purchased it from a co-sharer.
co-sharer,
Co-sharer would mean that shares are not determined.
yes.
You feel on merit also. Instead of this court making any comment, I think a simply cited dismissal would be okay. You will have the right to agitate the decree drawn. Section 47, we can't allow the scope to be expanded to the nature of inquiry you are seeking.
But our contention before the learned court was the suppression of facts, because admittedly we have purchased a land and the shares were not determined. As per section 44 of the Transfer of Property Act, even the co-sharer is entitled to sell their part of a portion of the.
No, at best, what you can do is that once you have raised an objection and you are one of the co-sharer of the land, your application can at best be treated under one under order 21
97.
97. Just a moment, let me just check up. '97 at best. And what is the nature of order passed?
Order passed, your lordship will find at page 127. The relevant portion, if I may take your lordship to page 130. Paragraph 5.
You see, another reason which arises on reading of this order is that you lay a claim that the title deeds which you are having was never set aside.
This is
In a partition suit, that is not necessary. You have purchased the
Not
share,
necessary.
it depends on the share which is determined in the
not necessary.
name of the, your vendor. In fact, if you allow this, execution proceedings to go on, then your right will be determined. How will you be adversely affected?
But
On determination
this
of
where
share.
we're finding it difficult because they are not talking about or determining any right of, that has derived from the sale deed.
No, it's never. Because whether your vendors have any right or not, that we don't know.
He has, because altogether 36 bigas, this is the admitted position in the plane, 36 bigas of land.
You see, the people who are there, they may not have simple, what you call 1/36 share. The persons who are before us may not have 1/36 share in the land.
But the petitioners,
Whoever is there, they are, you say that there are 36 people.
not 36 people, but only 36 bigas. 36
No,
bigas,
okay, how many defendants are?
or legally it's 3, my lord.
No,
But the
in this, in this suit, you have just shown us the defendants are 35, 37, 39, 42 people. The 42 respondents and the plaintiffs are 3.
plaintiffs have 3,
So
these
50 people have a share in 36 bigas of land. And what is the nature of share, we don't know.
But the person who filed the suit before the court, she was the second wife of the landowner.
Second, third, fourth, we don't
And-
know about that.
Yes, she
She claims to be a sharer of that land.
share of the land.
So if she is the sharer, she claims also for the minor children. So there are 3 plaintiffs. What share they will get, we don't know. How much share, there are 37, 42 defendants. That means 45 people are there. 36 bigas of land.
But if I may take your lordship to the prayer made in the,
It doesn't take us anywhere. Is a partition suit dependent on the nature of affair when a share is to be determined? Share is to be determined on the basis of many other factors. Even if you claim that out of these 36 bigas, let us say that the decree says plaintiff is entitled to 35 bigas. In a partition suit, he will not get it. Because the partition suit does not, it will depend on the preliminary decree and the assessment made as to what is the share. Then there will be a final decree determining the shares.
yes.
Hmm.
But when we tried to file the objection before the circle officer,
That will also be going to do it. You see, he is not the adjudicating authority. He will just visit the land, have the measurements done, and then give a report as to how many people came and how is the shares to be determined.
there is the
He is
difficult
not the assessing the court.
on ground, my lord, he is doing the entire,
He is only
Exercise.
doing the exercise of telling the court as to what is found in the land.
but he is not submitting the report also. Once he has submitted the report that this land is dark numbered is wrong, they come up with the amendment petition. But twice after the decree, the plaint was amended. Originally the dark number or from which we have purchased, those dark numbers were missing in the original plaint. Subsequently, after decree was passed, they filed the amendment petition in the year 2017.
Challenge those things, but
So some, my lord, discrepancy, my lord, been committed from the side of
not an
plaintiff.
appropriate way.
Then, my lord, your lordship may dispose it with a liberty to the petitioner to file appropriate application to determine their share during the course of partition.
No, that can't be permitted. That will expand the scope of execution. Execution, there will be only one direction by the court issuing the preliminary decree, which will have the contours of the assignment of the task to the land revenue staff, including the circle officer.
They have visited.
There cannot be 2 parallel
In fact, no execution case is pending naturally, my lord, because the PSET was issued to the deputy commissioner as per section 54.
But your section 47 application is there. And
In the meantime, if I get trouble, my lord,
this is on what point?
on the scope of section 47, here in the recent judgment where the Supreme Court was analyzing from the point of view of fraud committed during the course of obtaining a decree. Paragraph 15, my lord. I have marked it with the flag. Paragraph 15. Before analyzing the facts,
Just you want to refer to paragraph?
paragraph 15, my lord.
Hmm.
If I may read, my lord.
Yes.
Before analyzing the facts, it must be acknowledged that the present appeal arises out of a challenge to the order of the High Court under Article 227, whereby the High Court refused to set aside the dismissal of the application filed under Section 47 CPC. The scope of interference at the stage of execution is limited to certain exceptions. As per Section 47, the executing court is empowered to examine the questions relating to execution, discharge, or satisfaction of the decree. It cannot go beyond the decree, but at the same time, when a plea is raised that the decree is a nullity and hence unenforceable, the executing court is bound to examine and decide such an application on its merit. It is a settled position of law that a court executing a decree cannot go behind the decree passed between the parties or their representatives unless the decree is a nullity. The court must execute the decree according to its tenor and cannot entertain objections on the grounds the decree is erroneous in law or on facts, until it is set aside by an appropriate proceeding in an appeal or revision. A decree, even if erroneous, remains binding on the parties. A decree may, however, be challenged in execution proceedings if it is a nullity. For instance, if a person who was there at the time the decree was passed or where the cause of action was not maintainable, or if it was passed against the ruling prince without a certificate. An objection in that behalf may be raised in the execution proceedings. Similarly, when the decree is made by a court that has no inherent jurisdiction to pass it, an objection as to its validity may be raised in an execution proceeding if the objection appears on the face of the record. And 18, the
You know why these observations have come? In this case, why, on what facts it has been decided, you know that? The suit was decreed for a sum of 84,170. Now, the SFC said that 24% interest is,
yes,
required to be attracted. And therefore, this decree of 84,000 came to 22 crores. Correct?
yes.
Therefore, the Supreme Court says that it has to be gone into whether the decree is executable or not, and whether the decree is a fraud.
But I was on that fraud aspect because
But there is a specific finding of the Supreme Court
yes,
on facts. And that is why we are compelled to see this. You see,
I was just trying to draw an analogy of scope of section 47 for the present claim of the petitioner.
it's not because in the defense you do not take that plea. And now you take what is your defense? It's not that marriage is a case of nullity.
Suppression.
No. I may not know that you have bought shares of somebody. Maybe a surreptitious purchase. You have not told even your brothers that you have purchased the share of LDC. Can happen. Now, if let us presume that you have purchased that share, you should have informed in the trial court. You say that it's for ex parte. Okay. Now, what you do is you challenge it, the decree by the section 47. You don't file an appeal. That means the decree passed, which is to your knowledge, has attained finality. So section 47 must be dealt with the knowledge that there is a decree.
Yes.
And in what is the decree? To determine the shares. If you have lawfully purchased it, you will get your share. What is the anxiety that you will not get your share?
But unfortunately, the learned court has already determined the share. The learned court has not left it at the discretion of the collector as per section 50.
Let us say, if the court determines the share, how it is determined? So that
The prayer made in the plaint if I may take your lordship to the prayer portion first, page 39. That it may, the lordship has got.
yes, so
That-
they say that there's 36 bigha, 1 kata, 0 kata lacha of land.
Yes, schedule 1 and 2 of the same.
And they have they've got a decree for 12 bigha, 3 kata, 15 lacha.
Yes,
And so that part has to be separated.
yes,
And that is the share determined.
determined.
So that's why I said that how many people have changed is not that simple.
But collector is proceeding with the decree that has been granted by the learned trial court
You
without,
have to agree by that decree. You not come and establish your share, you can file an appeal and then still continue to assail that. How in section 47, the court will go behind the decree and assess whether the share determined was right or wrong. That is a merit. It's not a case of decree of nullity.
one document I have annexed though for the first time, because while going through the records, we came to know, because on behalf of all the proper respondents, someone else has received, shown to be received, which is thumb impression affixing on the paper.
This person who has come and given thumb impression, he has not challenged that it is not his thumb impression.
He is one of the petitioners before this honorable court.
But he is not, you see, what I mean is that somebody's thumb impression is there. Has he come and challenged it that this is not my thumb impression?
To be honest, for the first time, when we're preparing this file, we've gone through the records, we came to know this is the thumb impression he has put. And while we inquired, my lord, he doesn't know that he has even put the thumb because he signs.
Can we send for, we file the order for application for setting aside decree? That some impression you can have sent
No.
to the
No.
forensic
We have
examiner.
advised, my lord.
But those things you don't challenge. Please, what you call, please come to your application at this 47 application.
And regarding the sale, my lord, in the plain, this is the admission of the plaintiff.
Your application for setting aside is at page 110. Correct?
Yes, my lord.
Now, please, the text starts from
118.
118. You see paragraph 1, 2, 3, next paragraph 4, 5, 6, 7. Next is 7 confused with the page, next page also. Then 9 at page 13, sold some land. 10, 11, 12, 13, 14. Now we see that the thumb impression was not his, was never taken.
Yes, never taken, my lord. It is the admitted fact. I am admitting before this honorable because before filing the 47, this revision petition, for the first time, it came to their light, my lord.
It's okay.
When going through the records, my lord.
Still admit that.
In fact, before the, my lord, trial court, we, my lord, perused the records.
I'll tell you a horrible example. You see, one of the horrible example is that a lawyer accompanies the executant of a deed in the sub-registrar office. He agrees to stand as a witness. The sub-registrar accepts him as witness, allows him to sign in one page, and in the back page, they take a thumb impression of the lawyer. So even an educated person can give thumb impression.
Yes, that's what the case to us.
So whether the person gives a thumb impression of a signature, incidentally, no definition of signature in Black's Law Dictionary. No. It's a mark of a person given by that person or others by at his direction. So if today I have to give, and for some reason I tell my secretary, please do the signature and make it online, he does it. That does not make the order illegal or his action to be illegal. The Black's Law Dictionary supports us. I can permit him to put my signature and then send it. Made by the person, mark of a person made by the person or others and his authority. Merely by saying that one has signed can still be your signature. If this person says that yes, I was authorized by others to sign, I am sitting here in my home, my delivery of some this e-card company comes. In the morning, I give an order. Now it is going to my home. My family members will receive that. Put a signature. It is required to be made by the person to whom the consignment is addressed.
Yes.
That doesn't happen. My family members will be signing it. Not be wrong.
But my lord, instead of signing, my lord,
Some reason why not? I'm eating, I don't have the, I can't write with the left hand, I put my thumb impression and go. What is wrong in that?
yes, my lord.
You don't find it. And this paragraph 15 therefore doesn't help you. Yeah.
I was just trying to draw an analogy, my lord, how, my lord, the scope of
But on
47 can be enlarged.
Can the merit be examined of a decree in the guise of section 15 in non-executable, we understand. But is it not executable?
And the order 5 rule 11 says, my lord, the summons has to be served on each of the defendants.
We are not looking at that. We are looking at the scope of order section 47 application. We are not determining the application for setting aside the decree. But Mr. Vishwas, the problem is elsewhere. Whatever I am sitting here will become a part of the order if you still continue with the challenge. Would be better come at 2 o'clock, take the consent of the other side, withdraw it, and then take leave to file application for setting aside.
Yes, my lord. This leave may be granted, then it will be.
You take instruction, otherwise you will be offended. Take instructions and then withdraw it so that you don't put anything in the order.
Now, we have the instruction, my lord, we
We
have
have the
discussed, my lord. And with that liberty, if your lordship dispose it of,
Okay.
it will help us.
But Mr. S. Biswas, then it passes to the petitioners. Next one. The legality of the order dated 28/7/2023 passed by the learned civil judge from Daran, Mangalore. The execution case is not a issue.
No, my lord.
Execution case is
No,
not
my
a
lord.
issue.
No execution case is pending.
Passed in statute 13 of 2007. Thereby dismissing petition number 713 of 2021 at a cost of rupees 10,000. The petitioners, by filing a petition under section 47 read with section 151 CPC, which was registered as petition number 713 of 2021, dated 24/3/2021, has prayed for keeping on hold the by holding that the decree that was passed in CS 13 of 2007 was not executable under law. Next paragraph. On a query of the court, the learned counsel for the petitioner had submitted that when he said petition under section 47 read with section 151 CPC was filed, the decree was not put to execution. Therefore, if the decree is not put to exhibition and no exhibition petition is registered, five of a section 47 application in connection with the suit appears to be misconceived as section 47 applications is required to be determined by the court exhibiting the decree. Next, this stage the learned counsel for the petitioner upon traffic submits that the petitioners be allowed to withdraw this application and to approach the court or court by filing an application for setting aside the expanded decree. Step here is considered on the board. This the hence we go on the job. Liberty is taken.
Much obliged.
Yeah. That is,
Yes.
music somewhere.
This item 47, Lordship order, my judges may not reach Lordship. So
Orders will take up after motions. We are changing the
order
what do you
41
call
will be
the
taken
order of listing. After this motions, the admissions, sorry, orders will be taken up and then we come back to admission.
Yeah, please, sir. So this case arises from the manuscript number 14/25, presently pending before the learned civil judge junior division Bangalore. Lordship will find the plaint at page number 16. Onwards, my lord.
Just yes.
So I am the defendant here, my lord, in the suit. And suit is for damages and compensation for defamation below the rupees 5 lakhs. And here, my lord, page 17. Page 17, para 4, para 3, first of all, the para 3, wherein it is stated that the defendant is a class 1 contractor residing at Panjabari, Gauhati, Kamrup Metro under PS Satgaon, Assam. Then para 4, that the defendant as a complainant filed a complaint case against the plaintiff and against Sri Hari Prakash Karmakar in the Court of Learned Chief Judicial Magistrate Kamrup Metro at Gauhati on 24/7/2024, which is registered as complaint case number 498/24 under section 120B 420/506 IP. So prior to the institution of suit, a complaint case was filed by me against this plaintiff and this one another person. Then page para 5, it contains the contents of the aforesaid complaint, which runs page number 17, 18, 19, 20. Then, my lord, page number 21. So here, at para 6 of the plain, it says that the court of the learned chief judicial magistrate Kamrup Metro at Gauhati transferred the said case to the court of Srimati S. Khonikor, judicial magistrate first class Gauhati on so and so for this purpose. Thereafter 7. The learned trial court issued pre-defense notice to the accused respondent plaintiff by order dated 21/8/24, fixing 24/10/24 for appearance of the plaintiff, and accordingly in the next date on 31/20/25, the plaintiff appeared in the trial court and filed a show cause reply for dismissal of the case on the ground of jurisdiction. And the trial court fixed 10/2/2025 for hearing. For 8, why the suit was filed, it is written here that the learned trial court passed an order dated 26/3/25 by giving observation and finding that the court has no jurisdiction to proceed with the instant case due to lack of jurisdiction under section 202 of the BNSS, and accordingly the complaint is returned in its entirety for being filed in the court of proper jurisdiction. It is to be noted that till today no revision / appeal is filed by the complainant defendant. Hence the suit for damages and compensation protocol. So the suit, it arises from this complaint. Now, if your lordship come to, there are other 3 pages. Now, how the complaint case affect them? How it has defamed them? That is mentioned at para 9. That the defendant has made the imputations concerning the plaintiff intending to harm or knowing to having reason to believe that such imputation will harm the reputation of the plaintiff. The imputations made are not put in public in any manner. Such imputations have defamed the plaintiff beyond all reasonable doubt, in as much as the dignity, prestige, integrity, and reputation of the plaintiff has been lowered down in the estimation of the public due to complaint made by the defendant, and thereby such imputations have harmed the reputations of the plaintiff beyond repairs. The defendant has no special privilege to make such scandalous allegation as made in the complaint petition to ruin the reputation of the plaintiff in any manner. The defendant has done this with a common intention to harm the reputation of the plaintiff. And that the plaintiff submits that the action of the defendant in filing the complaint are not within the purview of the protections of his fundamental rights of freedom of speech as guaranteed under Article 19(1) of the Constitution of India. That the plaintiff submits that he has already suffered irreparable loss and injury in his professional and personal career due to filing of the aforesaid complaint, which cannot be compensated in terms of money value in any manner. And the plaintiff submits that the defendant is liable for the damages so caused to the plaintiff, and for that the plaintiff is entitled to get a compensation amounting to rupees 5 lakhs only from the defendant as described in the serial below. Then the cause of action for the suit arose on 24/7/2024 when the defendant filed a complaint case against the plaintiff, that is in Gauhati, my lord. On 24/10/2024, when the trial court directed to appear the plaintiff. On 31/25, when the plaintiff appeared before the trial court. And on 26/2025, when the final order passed by the trial court, on every moment thereafter within the jurisdiction of this court. So this is the case in the plain manner. And what I have skipped in para 5 of the complaint. So the complaint that I have filed, it arises out of this NICR case number 45/21, which was pending at the court at Bangalore. So here the allegation against this plaintiff and the other person is there. Your Honor, para 5 at page 17, my lord. May I read out, my lord?
What is what you said in conspiracy they do cheating? Separate property 525, 406, 420/506 they applying.
Pardon.
You have in your complaint referred to the conspiracy and deceiving and then cheating,
Yes,
120B, 420/506.
yes, yes.
That's okay.
So here Lordship will get a reference of one NICR case 45/21, wherein the present petitioner was the accused and this plaintiff was the complainant. And some sort of settlement took place, and in connection with such settlement, money was transferred to the other person account, and who happens to be an advocate therein in Bongaigaon Court, page number 18, my lord. And accordingly, an amount of rupees 2,35,000 only on 22/24 was paid to the accused number 1 through online bank transfer from the bank account of the complainant maintained with ICICI Bank Bishwanath bearing account to the bank account of the accused number 1 so and so. That after making the payment as mentioned above to the accused person, the complainant made a phone call to the accused number 2 and asked about the status of the withdrawal of the case. To which the accused number 2 replied that as the complainant was late in making the payment, the withdrawal petition was not preferred, and the accused person assured that on 22/2/24, the case will be withdrawn by filing a withdrawal petition by the accused number 1. That the complainant begs to state that on 22/2/24, he again made a call to the accused number 2 and inquired regarding withdrawal of the case, and the accused number 2 told that he filed the withdrawal petitions duly signed by the accused number 1. But as the case has been fixed on 27/3/24, the learned trial court has asked to file the same on the date fixed, that is 27/3/24. And in proof, the accused number 2 has sent a photograph of the withdrawal petition duly signed by the accused number 1, which is filed for the accused number 2 in the WhatsApp number so and so of the complainant from the WhatsApp number so and so of the accused number 2. That the complainant begs to state that on 27/3/24, the aforesaid withdrawal petition was filed by the accused persons in connection with the aforesaid case filed by the accused number 1.
That is not necessary for our case to know about what is there in the complaint. Come to the point.
Now, my lord, in connection with this suit, we have filed our detailed written statement that is annexed as Annexure 2, which is from page number 26. And, my lord, the complaint which I filed, that is Annexure 3 from page number 41. And raising the issue of jurisdiction, my lord, I have filed an application that lordship will find at page number 7, Annexure 7, page number 64. In terms of section 19 of the CPC, my lord. Page number 64.
Yes.
For no cause of action and for the statements that is made in the plain, which itself shows that the suit is barred by some law. And the law here, my lord, is the section 19, which, my lord, we have given a reference in our application that lordship will find at page number 66, our para 6. We have also quoted the relevant provision in this para, my lord, this section 19, that in terms of the mandate of law as prescribed in section 19 of the Code of Civil Procedure, this honorable court has no jurisdiction to try the instant suit, and the suit filed by the plaintiff is liable to be rejected in terms of Order 7, Rule 11 of the said court. Then we have quoted section 19. In the instant suit, admittedly, the defendant is a resident of Gauhati, and the complaint petition also filed by the defendant at Gauhati against the plaintiff and another. Further, admitted case of the plaintiff is that due to the filing of the complaint petition by the petitioner defendant at Gauhati, the suit for damages and compensation for defamation has been filed. But the plaintiff in the interplaint miserably failed to state and show that the wrong or cause of action arose at Bongaigaon to file the instant suit against the defendant, and the Honorable Court of Bongaigaon has the jurisdiction to try the present suit. Rather, admittedly, the wrong committed at Gauhati, and the cause of action has taken place in Gauhati, and the defendant also resides at Gauhati. So the court at Gauhati has the territorial jurisdiction to try the instant suit, and this honorable court has no territorial jurisdiction to try the instant suit. Under such circumstances, in terms of the mandate of law prescribed under section 19 of the Code of Civil Procedure, this court has no territorial jurisdiction to try the suit. Furthermore, the plaintiff also miserably failed to show before this honorable court that cause of action arose at Bongaigaon for filing the instant case, and owing to the aforesaid reason, the plaint filed by the plaintiff is liable to be rejected in terms of the mandate of law as prescribed under Order 7 Rule 11A as well as D of the Code of Civil Procedure. Now, Lordship, at page number 68, 70 onwards, the impugn order was passed. And against this application, my lord, the respondent side has not filed any written objection. So, they verbally argue the matter, and this is the impugn order dated 6/3/2026. So, the operative part, my lord, it starts from page number 74, my lord.
Yes.
Page number 74, the second para. I have given my thoughtful consideration to the matter in hand. Before considering and adjudicating the dispute between the parties, it may be relevant to look into Section 19 of the CPC. Section 90 of the CPC provides for the provision of filing suits for compensation for wrongs to person or movables. Section 19 CPC states as under the provisions quoted. Next page, my lord, page number 75. The provision of Section 19 of the CPC is specific in subject and clear in its operation. Firstly, Section 19 of the CPC provides for the provision of institution of a suit seeking restitutive reliefs of compensation on the basis of wrong done to the person or the movable. And secondly, Section 19 CPC offers and furnishes the option or choice of forum if the conditions indicated by the qualifying clause are satisfied in that wrong complaint of was done within the local limit of one court, while the defendant in fact resides or carries on business within the local limits of the jurisdiction of another court. As per Section 19 CPC, unless both these conditions are available together, so this is the main point here, no question of option or choice for forum can arise. The conjunction "and" in the qualifying clause of Section 19 CPC is very much indicative of this result, as is other cases where these conditions are not fulfilled or available. Such suit shall be governed by other provisions of the CPC. In a suit for compensation, the wrong done or complained of is the cause of action which understands and contemplates all the necessary facts required as a proof for claiming the relief. It must be understood that the phrase wrong done as stated in Section 19 of the CPC must not be used in any narrow sense, but has to be taken into consideration and understood in all its amplitude so as to afford the jurisdiction of necessary forum and consequently the relief. Invariably, the cause and effect has to be taken and read into one after another. The injury or actual wrong may occur at one place, but its effect may be felt or may have taken place at another place, or even may affect other places, and for all those effects, the cause of action would arise for seeking compensation. Thus, the phrase wrong done would clearly take in not only the initial action complained of, but also the resulting effect. Thus, the court within whose local jurisdiction the damage was caused or suffered or sustained would clearly answer the requirements of Section 19 for filing a compensation suit. In the instant case, it is the case of the petitioner that since the petitioner is a resident of Gauhati and that the complaint case 498A/24 was filed before the jurisdictional court at Kamrup Metro, Section 19 of the CPC clearly provides a bar to this court to try the money suit filed by the opposite party seeking compensation for damages. On the other hand, the opposite party has taken the plea that since the opposite party has suffered the damage within the local jurisdiction of this court has required jurisdiction to try the money suit filed by the opposite party against the present petitioner seeking compensation. In the instant case, the opposite party in its plaint as the plaintiff in the money suit has categorically stated that due to the filing of the complaint case by the present petitioner at Kamrup Metro, the reputation of the opposite party has been tarnished to a great extent before the public and beyond repairs. The instant case clearly appears to be one where the purported wrong done has taken place at one place and the effect felt at another place. In my considered opinion, considering the larger scope of the phrase wrong done used in the qualifying clause of Section 19 CPC, there is no bar in the jurisdiction of this court to try the money suit filed by the opposite party against the present petitioner seeking compensation for damages. In view of the same, the court does not find any merit in the petition file and this case stands disposed of. It stands dismissed. Now, my lord, what section 19 says
Yes.
that where a suit for compensation for wrong done to the person or to the movable property, if the wrong was done within the local limits of the jurisdiction of one court, and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdiction of another court. So here, in both the events, the wrong done, which is alleged in the plain, it is in Gauhati, because complaint case was filed at Gauhati. And admittedly, the defendant is also a resident of Gauhati. So these two options are given. The suit may be instituted at the option of the plaintiff in either of the said courts. So here wrong done is at Gauhati, defendant resides at Gauhati. So the suit will lie in Gauhati court. And by mentioning in the impugn order that lordship I have already read out in page number 75 about the conjunction and, the court says that both the conditions should be fulfilled, only then section 19 will apply. Otherwise, no. There lies the perversity here, madam. So this item number 11 and item number 12, my lord, both are similar because both the two accused of my complaint case, they have filed two separate suits claiming the same amount. Contents of the plaint are same. Order is almost same, copy paste type order, my lord. And so let notice be issued, let them come. And in the meantime, my lord, this case is, title suit is pending on 22nd of June. And in the meantime, my lord, may be pleased to state the further question.
We'll be dismissing your application. We'll be dismissing your application. For want of jurisdiction of filing, at best, you can apply under order 7 to 10 for the proceedings to be taken up at the court having jurisdiction. The claim cannot be rejected under order 7 to 11.
Then my lord, may be pleased to give us that liberty to approach the trial court again. If remedy lies.
No, that's for you to decide. We just had Mr. B. Boral and counsel to the petitioner. By filing this application under Article 227 of the Constitution of India,
Return of the
the petitioner who is the defendant in MS 14 of 2025 pending before the learned civil judge, junior division, that it was Bongaigaon. Has received the order dated 6/3/2026 passed by the said learned court in BJ case number 67 of 2025, by which application filed under order 7 Rule 11 CPC was dismissed on contest. Next para. In brief, the case of the petitioner is that he had he is a resident of Gauhati and he had filed a criminal complaint case under section 223 of the BNSS, which was registered in the court of the Learned Chief Judicial Magistrate, Kabru Metro on Gauhati, as complaint case number 498 superscript C, small c, of the 2024, which was made over for trial before the Learned Judicial Magistrate First Class, Kabru Metro, Gauhati. So by the said complaint, what the said learned court was the claim was made before the said learned court for taking cognizance of offence under section 120 capital B of the 420 of the 506 IPC. Agreed by the next paragraph is projected that agreed by the said complaint petition and on this complaint is not dismissed.
Yes,
Dismissed.
petition.
No, the complaint is not dismissed.
No.
What happened there?
It was returned, my lord. And we filed one revision.
Complaint case was returned.
Yes.
There is no concept of return in a criminal proceeding.
My lord, at page number 51, in the
51.
first title of our criminal revision.
The complaint petition was returned.
Revisional court order, my lord, page number 63. And about returning of the case, lordship will find at para 8 of the plain also, at page number 21.
What is amusing is that even that order is stayed by the appellate court.
Yes,
In that reason.
page 63, my lord.
It is projected that the said complaint case was returned by order dated 26/3/2025 by the Learned Judicial Magistrate First Class. Next, thereafter, the respondent as plaintiff had instituted money suit number 14 of 2025 before the court of learned civil judge, Union Bracket, Union England, Bracket, seeking damages and compensation for defamation of valued to be 5 lakh. Which is structured on the ground that the complaint petition was filed and the respondent was detained. The petitioner had, the Learned Counsel for the petitioner submitted that the petitioner appeared in the said proceedings and filed his written statement and filed a separate application under order 7/11, read with section 151 CPC for praying for rejection of claim. Just what we said, petition was registered as Mijje case number 67 of 2025 in MS 14 of 2025. Next one. The said learned court. The learned received that within the junior division that was by order dated 6/3/2026. Rejected the such clear. Hence this application. Next one. The learned counsel for the petitioner has had submitted that the application for under order 7 to 11 was filed on ground of lack of territorial jurisdiction of the learned civil judge within the junior division to Noida to entertain a suit for compensation for wrongs to the respondent, which is which could not have been entertained at Bangaigaon as the petitioner resides at Gauhati, and by filing a complaint at Gauhati, wrong if any was committed at Gauhati. And accordingly, by referring to section 19 of the CPC, it is submitted that the suit for compensation for wrongs has to be instituted at the option of the plaintiff, either in the court of local jurisdiction where the wrong was committed, or in the court where the defendant resides. This one. Next one. In the specific opinion of the court of the point, in light of the point raised by the petitioner, if suit is otherwise maintainable but has been filed other than in a court where the suit had been instituted, I could not make out a claim case for rejection of claim within the meaning of Rule 7, Rule 11 of Article Order 7, but it may constitute a ground for seeking return of claim under Rule 10 of Order 7 of the CPC. So this is not a case where any of the clauses of any of the clauses A to F of Rule 17 of Order 7 is attractive, CPC is attractive. This was. For reasons other than what the Donald Trump could have arrived. Court is of the considered opinion that on merit, one of the impure order cannot be interfered with. Then the order dated 6/3/2026. No, nothing contained in this order shall preclude the petitioner to take such steps, will be so advised. in the event the petitioner is of the view that this could also have been instituted in an appropriate court having jurisdiction. That option for the petitioner would also be available without the order of the court. The challenge to the Indian order the 6/3 2026 case in the judicial dissertation is rejected however with anybody to be petitioner has delegated over next circumstance. Especially now that item 12 also says
Item number 12, my lord.
here the case number is different
No, this is money suit number 15/25.
and the complaint is
Complaint is same, my lord.
same complaint.
Both are accused in the complaint.
Manuscript will be different.
Order dated is also same here.
15 of 2025. 15 order is same.
This case number is 68/25.
Hmm.
Order 7, Rule 11 application, this case number is 68/25.
This is case number 68 of
25.
2025. In MS 15.
Arising out of MS number 15/20.
Item 13.
Where please?
Yes, Mr. Abhishek.
The petitioner before Lordship is defendant in this case, my lord. The plaintiff has filed a suit for recovery of 10 lakhs as well as repayment of 20 lakhs.
Right. Right man is coming for a long course.
I'm not sure.
Right. No,
For a long time.
no criminals around. No criminals around.
No, criminals are there.
Okay. Yes, what brings you
What
here?
is happened, my lord? Someone was served, my lord. He was not there. He has gone for medical treatment. It was declared expired on 30/4/25, my lord.
24.
I prepared an application for setting aside, my lord. That was allowed. Your lordship may kindly come to the order, my lord. That is on page 25, my lord. There on medical ground, it was allowed, my lord. Only last part of the order, my lord, I agreed, my lord. That is page 28, my lord. 28, last portion, my lord. However, record reveals, my lord, that the certificate period of filing refused statement already over from the date of service of summons. As such, defendant is allowed to contest the suit without any refusal statement. That part I'm agreed. Because it is directly here. On medical ground, he has already set aside the ex parte order. He also have allowed it to file refusal statement. And that is direct.
Okay. But Mr. P. Kotabil and Senior Counsel assisted by Ms.
Miss Neha.
And Kashyap.
and Kashyap, and counsel for the petitioner. Next, the agreed by a part of the order dated 21/8/2025. Passed by the learned civil judge, Union Bracket Senior Division, was Vishwanath. In MS number 3 of 2025, by which the petition number 986 of the 25 under order 907 CPC in the order 907 led with section 151 CPC was partly allowed by setting aside the ex parte decree, but refusing to allow the petitioner to file written statement to contest this suit. Next one. The learned counsel for the petitioner has submitted that was a financial dispute between two sides. But when summons of the said Manisur 3 of 2025 was served, from at that time, the petitioner who had throat cancer was intermittently at undergoing treatment at Gauhati and Chennai. And during this period, he had also, he was also required to accompany his ailing father twice a week for dialysis, as his father was also suffering from kidney ailments. According to Thomas, when the suit was ordered to proceed ex parte, the petitioner, on coming to know about the ex parte order for hearing of the suit, filed petition number 986 of the 25, dated 27/8/2025, order 917, maybe section 151, yes, set aside the order of ex parte hearing. The party order is located. If you notice, returnable, due date after 4 weeks, returnable on Wednesday, petitioner shall take steps within 2 days for service of notice of the respondent by speed post with ED, as well as by review process. Next paragraph. In the next returnable date, the further proceedings of manuscript number 3 of 2025, pending before the Court of Learned Civil Judge, within bracket senior division, bracket Eastern Sorry, shall remain stayed. Next paragraph. Petitioner shall produce a certified copy of the order before the judge with the order to the it is like item 14. Please allow. Okay, in this case, I am the defendant in the suit pending against me. So there has been filed by the plaintiff, the respondent, for eviction and recovery of first possession. Suit was filed on 28/7/2025. I received the summons and I entered the appearance within 90 days. I have filed my written statement on 11/12/2025. Lordship may kindly peruse my written statement, page 45. Page 45, internal 43%. Page number? Page number 45, internal para 43. May I read it first? Yes. That before answering para 34 of the plaint, the defendants state and submit that they have strong case against the plaintiff. They are collecting all the necessary and relevant documents from various offices. While some of the documents already received by them, some of the documents are yet to be issued from the offices. And as such, along with written statement, the defendants could not get order. What's it in order? Page 201. My petition for leave to file additional case has been rejected. Page 201. On the same day of filing my WS Lordship, I have filed the petition for leave of the court to file my additional witness. Mr. D. Kalita, and counsel to the petitioner. Filing this application. Article 2.7 of the petitioner will be order dated 24/3/2026, by virtue of which leave was not granted to file additional legal statement. Next one. The case predicted by the learned counsel for the petitioner is that there are within 90 days from the date of service of summons on 11/12/2025, the petitioner has filed a written statement along with an application along with the petition number 3376 of 2025, dated 11/12/2025, stating that the witness statement has to be filed without necessary documents and pleadings, as they were correcting necessary documents. During the pendency of the said petition number 3376 of 2025, on 24/2/2026, you filed this. Okay. At the time of hearing notice, I have submitted them. The learned trial court below, I have thoroughly inclined to accept it. Did not accept it. Did not accept it. I have filed the additional adjustment in my case note. The additional adjustment that I have already submitted, that was inclined, I have annexed it. No, it was accepted by the court or not accepted? Not accepted. In the type of my petition also, I have mentioned this. No, that is not believable, because number one, the copy you are producing, the affidavit is not sworn, not presented before the notary. You go to a court and ask court verbally to accept something. There is a requirement of filing a petition. You don't do that. It's very difficult to accept these statements against the court. Why would you make a verbal statement to accept this? There is right. That the stating all the documents, the additional witness statement sought to be presented before the Gauhati High Court on 24/2/2026. But the state level court was not inclined to accept the same. In this regard, the state statement in light of just 5 to the resolution cannot be accepted because the affidavit accompanying the additional statement is not found to respond before the court commissioner or the notary public, and and the failure to accept the additional statement cannot be made already. But had to be when such prayer ought to have been filed in writing. Be that as it may. Here the nature of charge made, you should notice return of an also. Petitioner shall take steps within 2 days for civil because of the responsible by speed post with DD. Next one. So the interim measure in the next return will date for the proceedings of PS number 36 of 2025. Pending before the Gauhati civil judge number 1, junior civil judge, junior judge number 1, principal. Shall remain state. The petitioner shall produce submit copy of the order of the said law court. Bring the order to the notice of the said law court. This was
18th of July.
item 15.
One of the respondents filed a suit against one Rosal Sinha. And Rosal Sinha died, my lord, on 21/22. The council, my lord, by filing a petition, informed the same on 23/15. They did not file any petition for substitution immediately, my lord, and that petition was filed on page 49, my lord, next to 5 years or so. Yes,
Page
page 49.
this
Well, here he is, because the Malad, he knows Malad of him. At para 5, this is the only Malad, found Malad actually at page 50.
it's very difficult to dismiss cases for substitution. It's very difficult for us to dismiss the suit for
No,
substitution.
but I not on that, Malad. My, actually, I had to also see what order he has passed, Malad. The council also said that as the part proceeds to be, and notice should be proved, because who debated now? Who debated? Now the order was passed at page 59A.
59A. 69,
59.
15.
59.
Yes.
Well, hard, such construction whereby defendant paid for starting a separate proceeding. As much the council said the separate proceeding should be there. I have gone for the order, it is whereby the petition here has gone for the petition number, so there are plenty to state for substitution, also paid for council clear. Considering the facts that this court of the appeal, the plaintiff admitted that they bona fide mistake and right to survive the legal years of state, and for the interest of this petition number is allowed the court of reference to be paid outside as a condition. Plaintiff is directed to impede the legal years in patient. So this is the only one. In a case, my lord, where conventional delay is there and that admitted, my lord, only single petition was filed, my lord, without anything, and no, there is no order for setting aside everything. Then we filed petition, my lord, separate petition has been filed. Now we filed petition, my lord, at page 66. We say that, we should be given the chance, my lord. It says 63, my lord, I am saying. 63, we have filed a petition. If you have also see, my lord, our prayer is, my lord, reopen the matter abatement and pass order. This is what I. Well, at least, my lord, on consideration of delay and setting the abatement, my lord, notice should go, my lord. So that, my lord, it could not be done. And there is no order for setting the abatement also, my lord. Neither condition of delay. The order is very cryptic, my lord. That is why I have done. And now my petition has been rejected, my lord. Page 7. And there is mentioned, well, page 73, that in the, there is no specific order for satisfied abatement.
Where is the petition?
My lord,
Where is the petition?
petition, my lord, our petition is
No, the
basic.
petition for that,
Substitution.
substitution.
Yes, my lord, 49, page 49. That para 5, my lord, page 50. That is the only, my lord, explanation of that.
Being substitution.
It was filed
My lord,
on 16/11/2022.
yes. They admitted 211 days.
It's okay. And where is the order?
My lord,
Where is the order?
order is, my lord, at page 59. Page 59A. Page 59. Actually, no order for convenience delay also, just one like that, and no ethical ever. This is, they are getting orders, man, exam should be granted, my lord, the side. There is a delay.
Please tell us,
Yes.
you see this application at page 49,
Ah,
this was filed on 16/11/2022.
yes,
And the matter was taken up for hearing 27/3/2024,
yes.
after 2 years.
Yes.
In 2 years, something must have happened. You must have made an objection.
Well, yes, objection one, objection is filed, but no hearing because we are not a party. The council filed a petition, my lord, at page 57. This is person. He said that there should be separate, they started a, well, separate proceeding.
But that's okay.
And that is why, well, that has been detailed in the order. At both sides, whereby the defendant paid for starting a separate proceeding on the heirs and successors and
You see, after such, when somebody dies,
yes,
against the legal representative,
yes,
a separate suit will not lie. It
Separate-
has to be substituted.
yes.
It cannot be, this prayer was wrong.
No, maybe, my lord.
Correct.
But notice to be issued, my lord.
Not that. Notice should be issued, my lord, for regarding bonus, so that's why I'm coming. This application at page 49 was filed.
Yes.
On 16/11/2022.
Yes.
What happened? This 2 years time you did not.
Well, the presiding officer, said they were hearing for. I don't think, my lord.
This is who you are present.
Yes.
In the proceeding, you must know the proceeding. If it is pending for 2 years, restitution application is pending for 2 years.
Yes.
You must be doing something at that time. You can conducting this work. Having noticed that what is the prayer? After the order, how can you be given an opportunity to contest this again?
But council filed a petition on 7th of November 23. That page 57.
This is advocate for deceased defendant.
Yes.
That's okay. But what happened to this page 49? This application was filed.
Yes.
In 22. And you definitely you were present.
I can ask for a copy of the order, my lord.
Definitely you were present. That means you have knowledge of this petition. So why notice?
Yes.
The notice will go, well, supposing the late petition is dismissed for non-prosecution, or for abatement, we dismiss this suit or this application. Then if after some time somebody comes for setting aside this abatement, then notice. But if this application is pending and respondent is present, what is the requirement of sending a notice? You both are here.
Another one thing I'm meeting a lot. Respondents, there are many respondents. Now, many legal errors.
If your party is present in court, then you go to
One party will not do, my lord, because there are several persons, my lord.
Yes, I will ask.
One A to E.
You see, I see it very simply.
Yes.
Your instructing counsel is holding the brief for all. That means everybody has knowledge of what is happening in the court. But you see, there are 5 defendants, one may not be in court. But you are holding the brief, he is holding the brief for all 5. So it can't be said that 1, 3, 4, 5 knows, 2 does not know.
I shall take for instruction.
Here made by Mr. Jean Sanger and my counsel assisted them to cover impossible. Not today. This form. When
After 2 weeks.
this after this after keep the Item 16.
The private proceeding, my lord, I filed evidence and affidavit. I mean, in the evidence and affidavit, my lord, the marking of the will as exhibit 1, that was inadvertently, the one was not taken, but it is missing in the evidence and affidavit. And that is why I filed an application before the honorable district judge that this may be allowed to be corrected. My lord, the process is, this may be allowed to be corrected, my lord, under order 18, Rule 14(1)B, my lord, by additional evidence, giving additional evidence. My lord. But it was not allowed, it was rejected. My lord.
Where is your petition?
My application at page 24, my lord, in except 3. You know, only since the provision was not mentioned, that is why.
Mr. D. Chaudhary Gamal. Comes to the petition. Next. complete by the order dated. Order is 18/2.
Order 18, in fact, I normally go to the typing order 18.
No, which page is your written order?
The order is annexure 5, the
Page 28.
last page, page 28.
Thank you for the order dated 18/2/22, passed by the Economic District Judge Bani. By which petition number 103 of 2024 was rejected. And present application is filed under Article 227 of the Constitution of India. Next, the learned counsel for the petitioner has submitted that in the proceedings of PS within bracket P, probate number 1 of 2021, the petitioner has filed his evidence. You are the petitioner.
Yes.
The proceedings.
Yes,
The plaintiff of the petitioner is the plaintiff in the said proceedings of PSP, the probate number 1 of 2021, had filed her evidence on affidavit. However, due to inadvertent mistake, the will remains to be marked as Exhibit 1 due to marked as Exhibit 1. And also left out in the, to be mentioned in the evidence on affidavit. Accordingly, in order to correct the said inadvertent mistake, the petitioner had prayed to allow correction of the evidence on affidavit to reflect the will as Exhibit 1. The respondent side had filed the objection. So how on the level to take this application? Next. The notice regarding on so and so. Petitioner shall be expressed or serve the notice on the respondent. Respond by speed post in daily. In the next returnable date. For the proceeding. After the before the court of law decision from the right and the state.
But we encourage the partner of the
Item 51.
Similar to the one that moved on the other day, madam. Here also, madam, the suit is filed against the then DC, madam. Here the DC, the petitioner as the deputy commissioner had passed an prohibitory order, madam, under 144. Now, thereafter, the brickling of the plaintiff was sealed. Against that, she came up before this honorable court and the sealing of the brickling was interfered with on some other ground, madam. But the prohibitory order which I had issued, madam, was not put to challenge. Then there was a notice issued, madam, at page 63 on 16/1/2025. Although it is not stated that it is a notice under ATCPC, but the learned trial court holds this to be under ATCPC and substantial compliance, madam. Now, even if I concede to the extent that this is under ATCPC, madam, and Lordship will kindly mark the date at the top, madam.
Page
Page 63.
63. Yes.
The notice is dated, my lord, 16/1/2025. Even if I concede to the extent that this otherwise meets the requirement of 80, although it does not, my lord, then the suit is filed on 1st of February, my lord, within 15 days thereafter. So applying, my lord, that Bihari Chaudhary's case and that 2007 judgment, my lord, only remedy is to, my lord, only way out is to dismiss, reject the plaint under order 7. Because the finding of the London trial court is that it is substantial compliance, my lord. Page 111. Similar to that earlier order, my lord. And there is no application from the other side that this order is wrong. Page 111, my lord, just above the
As district commissioner, part of your job is to remain there also.
and surprising, my lord, both the two suits are filed on the same day.
That's okay.
That's okay, my lord. I'm just saying, my lord, just pointing out. There is no bar as such. But the suits are filed on the same day.
You see, we can't have any meaning out of that. Because if I read
Absolutely, absolutely.
If I read today's first list and find 10 cases of yours, you can't presume. The
Well,
connection between everything, no. Yes, Mr. What do you say this time?
And should I place those judgments, my lord?
Yes, please pass it on. With a bit of a plan. Yes, Mr. Hawk, what do you say?
Yeah, my lord, the petitioner, my lord, first of all, my lord, said, obtain, my lord, consent established, my lord, of a big clean, my lord. Your lordship will find at page 48, my lord. The big clean, my lord, here obtain the consent to establish, my lord, from the competent authority, pollution control board of Assam, my lord, page 48, my lord.
Yes.
My lord, pollution control board has allowed me to establish a big clean, my lord. And also following the other formalities, my lord, the petitioner had established the, my lord, the brick clean, my lord, and collected the raw materials for his production, my lord, and waiting for the consent to operate, my lord, from the pollution control board, my lord. While it says, my lord, the petitioner is waiting, my lord, the district commissioner Nalbari, my lord, page 57, your lordship will find, my lord.
See?
57.
Yes.
Very well. A consent, my lord. My lord, subject action against alleged violation of laws by the Assam Clean Establishment Regulation Rules 2013 by J.R. Pasame. He is the husband of the testimony number 1. Whatever, my lord, this act, my lord, this rule, my lord, that is not yet being, my lord, gazette notified, my lord. I am going, my lord. There, my lord. Sir, with reference to subject, I am directly to encourage here with the inquiry report regarding the violation of norms of the Assam Clean Establishment and Regulation Rules 2013 by J.R. Pasa and to take immediate necessary action as follows. Take necessary action for healing of the images matter. And also take necessary action to lodging an affair of criminal nature of acts. Here, my lord, since, my lord, the clean, my lord, had yet not been operated, my lord. So is the violation of the any norms of the that regulation. That was not also in force, my lord. It was just regulation, my lord, that was not yet gazette notified, my lord. On that basis, my lord, they had sealed the premises, my lord, quickly, as well as, my lord, they have lost the affair also, my lord. And as a result of which, my lord, the petitioner, my lord, the owner of the
Nobody is questioning why you filed this suit. That is not the submission of Mr. Deka. He says that you have filed a suit, you have given notice, and before the statutory 60 days period,
yes, my lord.
you filed the suit, and therefore it's liable to be rejected. Well, in that previous notice, my lord, case 63, my lord. My lord, 10 days time was granted. 10 days time was granted to the, my lord, to district commissioner, my lord. Now, please tell us, did you take a leave of the court to file it, file this before the statutory period? No, ma'am. Send it back to the state grand court. This, yes, my lord, they have not yet filed their detailed statement of correct. Where is your petition? Good, my lord. Because petition is where
My petition is at page 80, madam. And the objection to 80 CPC is at page 83. Para 6. Date of filing of this suit, lordship will get at page 116. Date of filing is 1/2/2025.
page.
116. That is not in dispute.
In this order, with how this ATCPC has been dealt with,
Page 111, madam. The discussion starts from page 111, 110, madam. Relying on two Supreme Court judgments, my lord, it has been held to be substantially complied with. Page 111. My submission is that if it is substantially complied with, if it is deemed to be under 80 CPC, then no suit could have been instituted prior to 16/3/2025. Page 111, second last paragraph, this legal notice is found to be substantial compliance of section 80 of CPC. As such, this ground taken by the petitioner is not found to be a tenable ground.
right. Mr. Andekar, let me proceed to the. Municipal Council assisted by Mr. B. Chaudhary and Council for the petitioner. as well as Mr. S. Hawk, the official respondent. The notice of this application filed in Article 227 of the Constitution of India to say the order, the interim order dated 1/4/2026, passed by the learned civil judge Bracket Senior Division of Mumbai in BJ case number 51 of 2025, by which application of order 7/11 and with order 16/6 was rejected. One is also for the petitioner submitted that as per the interim order, the Donald trial court has held that the issuance of notice under section 80 CPC, there was substantial compliance. But there is that notice which states.
Notice is at page 63.
But the said advocate's notice is dated 16/1/2025. Served on the petitioner on 18/1/2026 or 25. But the the manuscript number 13 of 1025 was filed and registered on 1/2/2025. Before it is the filed before expiring before expiry of 2 months after the notice should not be maintainable. That is 8/6/2026. This one. The response on this the responsible one, plaintiff has entered appearance from for the time being issuance of notice on responsible is dispensed with. Next one, this one. 8/6/2026. Till the next date of the further proceedings of management number. What is the number?
2025.
2025. Pending before the court of London.
Civil judge number.
Civil division number, Certificate State.
Okay.
It's 52. Make resolution. Challenge my lord, Mr. Three is 18 minutes. Hmm. 18. Whereby, my lord, the cross examination as well as the evidence of the prisoner will not be considered by the court, my lord. Parties are represented by the counsel of the prisoner has filed petition number 12 seeking another date for cross examination of PWS on the ground stated in the petition. On appraisal of the case by court, it appears that the petitioner has already availed several adjournments in prayer of the petitioner by petition number 7 is rejected. Evidence rendered by the petitioner will not be appreciated. Learned counsel of the opposite party has declined to adduce any evidence. Please answer for argument. Director of petitioner filed an application for review of the order. Yes. That is my lord, page 20, my lord. Page 20. Page 20 is the petition, my lord. Seeking review of the earlier order, my lord. So some my lord, medical certificate and medical document. But by order dated, my lord, 6/4/26, that application was rejected. Before that, how many exams have you taken? There are number of exams. There are initially, my lord, petitioner filed his evidence, my lord. Thereafter, some examining was there. Thereafter, my lord, petitioner filed witness of another person, my lord. Altogether, my lord, 4 witnesses are there, my lord, including the petitioner, my lord. Now, my lord, petitioner, my lord, next date is 25th, my lord, on Monday, my lord. Petitioner is ready to, my lord, appear before the court below, my lord, on Monday along with witnesses, my lord. One opportunity may be given, my lord. And this is in reference to LA case, my lord. Petitioner seeking, my lord, enhancement of the, my lord, award amount. If evidence is not appreciated, then, my lord, the whole thing will go, my lord. On Monday, my lord, petitioner will appear along with his witnesses, my lord. Petitioner also filed another application under section 151, my lord, that order must be contained 37. And fix the matter on 25th, 2026, my lord, for argument. Case 13. Yeah, the issue notice, the bigger submission.
Number 17, lordship. In the petition, they have stated that the plaintiff could not be present because he is announced the work, my lord, and could not inform the other witnesses.
Yes, there is some
Yes,
mistake.
lordship. And subsequently, he has stated that due to medical ground, he is not present in the court, lordship.
There is no private testimony, my lord. So let's discuss it on Monday, my lord, petitioner will appear, my lord, along with witnesses, my lord. Monday is the next week, my lord. With any condition, my lord. Let's have one of them for the petitioner. Did you government, the government of the referee for the respondent. Everybody, closure of evidence. The order to the 19/1/26 and injection of video petition, the order dated 6/4/26 and 27/4/2016. The petitioner is the asked by the owner. Additional, this is just one of the last para. In LA case number 154 of 2017, and present application. 8/6/2026. After this application is circumstantial on the state. That's correct. And the next date of the state, the petitioner shall produce copies of order sheets. From the date. And the case was ready for hearing and for evidence. In the date prior to 19/1/2026. So whenever the court examines as per one examines, the petitioner present with the evidence of capabilities. This from 8/6/2026. So this copies of the orders, the transfer. Relation.
May be the lordship. In this case, lordship, the petitioners are plaintiffs, lordship. They filed the suit against government as defendant number 1 to 4, saying that their lands were wrongly made as government, and accordingly they have filed one injunction petition also. An injunction order was passed in the year 2015, that is Annexure 3, page 51.
How does it be maintainable?
Lordship,
How does it be maintainable? That's all.
that injunction order pertains to the defendant number 1 to 4. So,
Saying that you're wrong, your land has been wrongly made government land.
yes, lordship.
How is that, how is that?
So they prayed for conversion of the land to Patta land, and lordship, as it was wrongly.
That will not lie.
Lordship, that is the prayer portion I.
But
Thereafter, lordship, some
use of that nature is never lie.
lordship, thereafter some private respondent appeared and they impleaded themselves in the said suit and filed their written statement also, lordship. So basically now the suit is pending between the plaintiffs and the impleaded defendants. And both parties are claiming confirmation of possession.
Get that land over government land, you can't get it, it is not maintainable.
But lordship, their prayer is written as for declaration of plaintiff's landholder right to moros over the land described in the schedule below and for confirmation of possession. For declaration,
How do you derive title?
lordship,
How do you derive title? Without title, how can you maintain a suit for declaration?
their case is that it is their purchased land that was wrongly made government house,
Your statement is that the land was made government land.
lordship.
So if it is a government land,
It was wrongly made government cast land.
that is to fly.
But the suit is pending since long, and subsequently some defendants appeared and they said that it is their purchased land, not the purchased land of the plaintiff. An injunction was also given by the learned trial court against the defendant.
Should we extend any challenge to whatever is happened?
And now I am challenging the order passed by the learned trial court, lordship, directing the OC to furnish the copy of 2015 to the police station not to disturb the possession of the impleaded defendants by the plaintiffs as well as by the police, lordship. So I am challenging that order only before your lordship. For that only, I am relying on the 2015 order. That order says that lordship government should not, the status quo over the suit land has to be maintained by the both the parties to protect the suit property. And thereafter, the private defendants, they appeared and impleaded themselves, lordship. Thereafter, we filed an application that is Annexure 4, page 54. Paragraph 2, that the learned court by an order dated 26/2/2015 in Miss Case number 73 of 2014 passed an order of status quo in respect of the suit land, and the said order of status quo is still in force. That the defendant is Raju Mia, these are the impleaded defendants, and Belaluddin on 8/11/2002 set up water pump and began to suck water from the suit land with a view to cut earth from the suit land, and broadcasting in the locality that they will cut earth from the suit land and will change the nature and feature of the suit land. The suit land is borough paddy cultivable land and low-lying land, and if the defendant will suck water from the suit land and will cut earth from the suit land, it will cause change the nature and feature.
To respond to this, take it up tomorrow, day after tomorrow, sorry, the Monday. You see, the issue is that the land was made a government land.
Lordship,
Right here only it has been done.
lordship,
Every land which has been made government will be by virtue of some orders passed by the administration. Correct. Now, you, in this, in the frame, which you have filed,
yes,
please come to the prayer,
page 40.
page 40. For the government orders to make the land fast, not under challenge.
That order is not there. We are not aware about any order, but we have stated
Actually,
it.
government will definitely contain, the data will always contain how it has been made as government land.
There are so many cases I have found from Zubri side also, lordship, due to non-payment of revenue, they have made the land government fast,
There has
but
to be
no
an order.
proceed, but no
You see,
proceeding was there.
For non-payment of revenue,
Yes,
it's permissible under the land revenue to make it.
yes, lordship, under regulation 70.
take
But
over.
lordship, they have not maintained any procedure, they have not auctioned. So we have to challenge through a suit as disputed questions arises, lordship.
No,
I have filed some of the
And the
writ
government
petitions
can advise
also,
on that.
lordship. Writ petition is not maintainable as observed by
I
this.
understand, but see, why not file a suit against, the Kazakhstan National Park, that this is my land, only made, for wildlife reserve. I have to be some basis, you derive title from somewhere.
Lordship,
Look at this. For declaration, the plaintiff's landholder right.
they are relying on
Landholder right.
purchase deed.
No, words are very important. Landholder right,
Yes,
not proprietary right.
lordship.
Land under the land revenue should have proprietary right. You don't claim that. Landholder's right. You don't claim title. Then what is a landholder right?
Lordship. In fact, their case is that in the year 1977, they have purchased.
Then we seek title. See, a purchase, let me tell you,
Lordship,
I today claim that I have purchased this type of property.
lordship.
I have a sale deed. Will it make the deed correct and then I become the title holder? But if someone files today a suit asking for an absurd declaration, the owner of is his. He says that he has purchased it from whom? He says to purchase from A. He must show to be a title holder and then the transfer. Those things are not even there. You claim taxes from whom?
But defendants never raised that issue that the suit is not maintained.
But here we are looking at it, we are looking at, we are exercising jurisdiction on that.
Yes, but that is true, Lordship.
Be prepared to take it up on Monday.
Yes, Lordship may fix it on Monday.
You also be prepared. Take assessment of revenue authorities and respond to it. This is our study and it's senior counsel, study petitioner and the government and government, senior additional senior government present. And put various to the tentative date in school. Then counsel for the petitioner. Some time to address before. Let's say some time to address before. Next list on. They will be 25th.
Lord. Public.
There's a prayer to upgrade one matter.
May I please, Your Lordship? Lordship, my transfer petition, Lordship, I filed in the 31.
Please button up your court first. Please button up your court. Because button is up. Yes.
Don't have any objection. Lordship, I'm for the petitioner. I filed for the transfer of the instant case from Principal Judge Family Court number 1, Lordship. Lordship, I'm for the respondent. We don't have any objection with the transfer.
Where is your petition and where is the order? Which page is your petition?
Of the briefing, actually. Lordship, my instruction was actually to withdraw the instant case to the Lordship, but.
So you
that's
want
why
to
I
withdraw it?
Yes, Lordship, but then then my learned friend told me you don't have any objection if the matter is actually transferred. That's why he didn't bring the brief to the Lordship. My instruction was to withdraw the case to the Lordship.
Lordship, we don't have any objection if the same case is transferred to the other family court. We don't have any objection if the same is transferred.
That is why I didn't brief the today I came to know that they don't have any objection, Lordship, if the matter is transferred actually. Initially, they filed the objection, but then today they don't have any objection, so I didn't bring the brief, Lordship, today. My instruction was to withdraw as my grievance was with the earlier petitioner, Lordship. Since he's retired, so I don't have any objection if the matter is there, remains there in the court, Lordship.
Okay, then we'll allow you to withdraw. Your name?
Please talk about the Lordship.
But this speech, Chakravarti Land Counsel to the petitioner as well as this.
Awasumi on behalf of MK Augustine.
Land Counsel is taking for the response. Next, upon instructions, the Land Counsel to the petitioner seeks to withdraw the petition. There is allowed. The matter stands dismissed on withdrawal. Rise, other matters will have to be adjourned. The members of the bar, I have to rise. Some administrative work I have to do.
You're right.
If any interim orders have to be extended, please tell the court master to do that.
The item number 47 may be listed on Monday. Official administrative work I have to do.